Welcome to EB-5 Investment Voice, where attorney insights intersects with immigration investments. If you are a foreign investor, domestic fund manager, or enterprising entrepreneur and want to get the most out of the EB-5 program, you have come to the right place. I'm Mark Deal, and I'll be your co-host on this journey. I'm joined by your host, Mona Shaw, and other attorneys at Mona Shaw and Associates, as well as immigration leaders from around the world. So let's get into EB-5 Investment Voice. You know, Mona, in all the years that we've been doing this show, EB-5 Investment Voice, we've covered a lot of topics in EB-5, and there's a lot of resources and communities that serve various segments of the EB-5 community. There's attorneys like you. Of course, there's agents, there's regional centers, there's the developers, and of course, there's the people on Capitol Hill that make things happen or stop to make things happen. But really, it's all about the EB-5 investors, and that is the American Immigrant Investor Alliance.
Right. Well, sometimes their goals do align with the other side of the coin. Maybe you can call it the dark side or whichever you want to say. And sometimes they don't. And they've been on our show, of course, before, and it's good to have them back.
Yeah. Welcome back, Ishaan Khanna, based in Washington, D.C. He is the president of American Immigrant Investor Alliance.
All right. Thanks for having me.
Well, as you know, Ishaan, we do like to take micro topics by the head and really twist things around. And we've been discussing wait times and backlogs on our show and in blog pieces forever because they are important. You know, it's one thing about getting an investment and knowing the right place to invest and stuff. But if you're suddenly investing and suddenly you find out that you can't actually come to the US or you won't actually get a green card for years, that can really put a spoke in the works.
Yeah, I couldn't agree with you more. And, you know, just from an investor perspective, given the existing processing times and how long it's taking for things to move forward, I don't think a lot of high net worth individuals feel inclined towards investing in EB-5 when the wait time just to move to the country could be around 4 or 5 years.
True, but we're not the only country where it takes that. I mean, Canada has taken around about 4 years as well. And the problem is, though, here is that so much within the EB-5 process is not designed around waiting 4 and 5 years. They've had to redesign things because of that. When I first started doing EB-5, we used to get approvals within 2 months. And then it made sense to have escrow accounts and keep all your money in escrow and all that kind of good stuff, which is all there to protect the investors. But slowly, so many of the protections have been eroded because of these lengthy wait times.
Yeah, you know, I was having a conversation with an attorney not too long ago, and she was saying that it's a little bit absurd that companies, regional centers, are going out there and spending investors' money even before CIS, the agency, has even vetted the investor source of funds and has given the stamp of approval. Yeah, you're right. Back in the day, it used to be you put the money in escrow, only after your I-526 gets approved, the money will be spent.
I know. Well, that can't actually happen now because if it's going to take years and years, then obviously projects can't wait. But at the moment, it's really up in the air as to what wait times people are facing.
Yes, that could be one way to say it. But I think that it's important for future investors to also look at what is currently happening. You know, we're seeing investors who invested in late 2018, early 2019, now moving to the United States. Now, of course, there was COVID, there was the regional center lapse and all of that. But I think investors, future investors, need to keep this in mind, that there has been issues with the program. There used to be a point of time, like when I did EB-5 in 2016, I got my approval in 10 months. I had my green card exactly about 18 months from the date that I wired the money from my account.
Well, very lucky, very lucky compared to what's happening now.
Is that luck, or as I say, an efficient administration? If the government that I am looking to basically live under is performing efficiently, that's the country that I want to be in. And when the greatest country on earth is taking forever just to process my immigrant petition, you know, I'm not so inclined towards that anymore.
True, but some things were there. Back in 2018, I was at an event where Charlie Oppenheim did say that there was going to be a backlog in, for example, in India, for Indian-born immigrants, which would amount to almost 5 years. And there was a ton of lawyers who didn't say anything. They lied. They just went out there and didn't say anything to any of the investors coming in. And consequently, many investors did invest in 2019. Now we are facing a backlog for all of those investors.
Yeah, I mean, I think a lot of lawyers at the same time did do the right thing and did make their disclosures, and a lot of lawyers did not. I do come across investors who do say to me that, yes, I was aware that there was a risk of a backlog and I'm fine dealing with it. I just want some accurate information as to how long this backlog is. And then I also come across investors who were like, yeah, I was never told about this backlog. My agent, my attorney just pointed to the visa bulletin and said, look at that C, look at that current, you'll get it. There's not much of an issue. I don't want to call people in your field liars, but I do feel that the impression that they gave to their client was not the right one. Well, and I think being honest and open with your client before he makes this life-changing investment is incredibly important. You know, whether it's giving them an accurate idea of how long it could take for them to move to the US, or at least a decent guesstimation, or at least show them, sort of past performance and show where investors are. And at the same tune, also make them aware that, there's limitations to what an immigration attorney knows.
I can argue with that here because we have opinions and we may not be pushed, but we can give our opinions.
100%, but you should also make your disclosure that, hey, maybe I don't know what the future could look like. Just like you should have told your client, hey, I don't know what the future backlog could be. Here is the data. Here's what it looks like. Yes, the visa bulletin says current, but maybe if you're investing in a rural project today, maybe that category could be backlogged tomorrow, forcing your wait to be even longer. I think those sort of disclosures are extremely important.
No, disclosures for sure are important. When it comes to abilities and everything, then obviously you have to look at the experience and what that particular attorney does. Maybe that attorney doesn't touch visa processing and has no idea. Then they should say that we don't have anything to do with that, or they don't touch investments, or they don't even understand how an EB-5 project is structured, and so are not qualified to be able to give you an opinion. However, at this stage right now, I think it's almost impossible. I mean, people ask me all the time with the new set-asides in RIA, the rural is supposed to be expedited, or the TEA is going to be faster, isn't it? When will I get it? I honestly have no idea. I don't know how long USCIS consider, priority processing, whether they consider priority processing to be 1 year or whether they consider it to be a few months, whether TEA is going to make any difference. I just don't know.
I agree. And at the same tune, the attorney should also disclose that there are people waiting since 2018 for their I-526 to be approved. So sure, you can invest in a priority processing project, but does that mean that USCIS will prioritize your petition over an investor that invested before you 2-3 years ago? Is that the kind of program that you want to invest into?
Well, they are going to do that as far as we can see with regards to at least rural processing. That's exactly what these set-asides are going to do. But anyway, before we get into the good and the bad and the ugly, Ishaan, let me ask you, you guys at AIIA have come up with, what is it, a calculator, a time calculator?
A visa wait time calculator.
So a visa wait time calculator. Tell me a little bit about it.
Sure. So I think a lot of this originally came from the data that we managed to obtain using our Freedom of Information Act request. We made a FOIA request a while back. Of course, the agency did not respond to it. And so we sued. We're now in a settlement with them. They actually have to hand over about 500 pages of documents every single month. And we've been going through those releases, combing through them, trying to find any useful information. And of course, we came across one of our requests, which was to give us the I-526 pending data as of March of 2022. So utilizing this data, we've now sort of been able to add up other data from other sources and now put together a fairly decent analysis as to what the estimated wait time could be for an investor, specifically from a backlogged country, how long it would take for them to at least see their priority date become current on the visa bulletin. Now, I'm not saying that this is when they'd get their green card, because, who knows, maybe CIS would wait until the priority date becomes current for them to even adjudicate that petition. And then they'll go for the visa interview, which could happen 7-8 months later. And then you enter the US and then you get your conditional green card. But they should at least give investors an idea as to when a visa would be available for their specific priority date.
Well, that will certainly be very helpful. But of course, we're talking about USCIS, and I don't know if any litigation of that nature would be forthcoming in between. How are you expecting that anyone from CIS might also utilize your methodology?
I mean, they're free to do so. So look, our calculator isn't estimating anything for future investors. We purely do it based on the data that we have. So just to kind of sort of give you an idea of what it would look like, right? Like say if you've invested in March of 2022 and you're from China, and now you're wondering, hey, what is the wait time going to be in front of me? So we've got a number of the pending I-526 petitions from your country. We do have the State Department data, as well as information as to like how many people are waiting for a visa to become current. So you add all that up, and now you have an idea of how long it could take for all the visas to be issued in front of you to eventually reach you. And then, of course, you can make your own estimations, such as like choosing how many dependents there could be per petition, how many people will actually receive an I-526 approval, and then how many people will actually make it to the visa stage. So once you sort of pick and choose your variables, now you have an estimate.
Right. And actually, I find this is going to be extremely useful. And I'll tell you where. When we speak with families who are wondering whether or not a child who's maybe 18 or 19, whether that child will age out, should they do the child or should they do the parent? That's where this is really going to be useful.
Yeah, I agree. Keep in mind, though, this would have to be for someone who's already invested. For someone who's a future investor, we are hoping to get this data from CIS, which is pending I-526 petitions broken down by country of chargeability, by set-aside visa, set-aside category, and then from there, an estimate to basically show what the latest data we have. Let's just say if it's this month. Now you can sort of estimate based on the pending I-526 petitions of each country what the worst case scenario could look like if that particular country only gets its specific limit of visas, how long the wait time could potentially be.
Right. It is going to be a little difficult, though, because currently USCIS are in around about May of 2019. And we know because of the deadline in November that there was a tremendous amount of visas which were pushed through in October and November. I think it's going to be difficult to calculate because of that huge number. And then, of course, after November, there was very, very little.
Yes, there were lesser petitions in 2019, but if we have the number of petitions that were sort of being filed overall all the way up to 2022, you can sort of make estimations. And if you get an idea of what the volume was in every quarter or every month, you can make some decent estimations as to like what your wait time would be, even if you're, say, a mid 2021 or a mid 2020 investor. Yes, November 2019 had a big surge, but if you can sort of estimate demand over that period of time, or you can analyze it, you can get an idea of what that would look like.
So, Sean, obviously you were able to pull lots of data from which you were able to model in different ways. Was there any insights or surprises that you were able to get or extract from that before you put together your calculator?
There weren't really any major surprises. For example, when we sort of put together a chart showing the I-526 receipts sort of by quarter and by month and all that, of course, November 2019, huge giant spike right there.
Yeah.
But at the same time, I think we found a lot of interesting stuff in our FOIA requests and responses, given the fact that we had asked for a lot of internal emails and memos, and seeing how the different folks within CIS and all the departments sort of internally make decisions and how they communicate with each other and how, congressional staff like interacts with them and seeing their email exchanges, I think is fascinating.
So it sounds like you were able to get a lot of like qualitative insight via a lot of that quantified data to model.
Oh, yeah.
Can you give us some examples? Promise we won't tell anybody.
So my response would be that is to keep an eye out on our blog. We're going to be releasing some really interesting stuff. I think most recently we saw folks that work within USCIS talking about Suzanne Laziki's blog. And I thought that was really funny. And then I just in terms of the decision-making process for an agency just to respond to, say, a member of the press on a comment, such as, give you a minor example, 2 days before the petition is due, 3 days before the petition is due, 4 days before the petition is due, 5 days before the petition is due, 6 days before the petition is due, 7 days before the petition is due, 8 days before the petition is due, 9 days before the petition is due, 10 days before the petition is due, 11 days before the petition is due, 12 days before the petition is due, 13 days before the petition is due, 14 days before the petition is due, 15 days before the petition is due, 16 days before the petition is due, 17 days before the petition is due, 18 days before the petition is due, 19 days before the petition is due, 20 days before the petition is due, 21 days before the petition is due, 22 days before the petition is due, 23 days before the petition is due, 24 days before the petition is due, 25 days before the petition them denying the 485s, the adjustment of status petitions during the lapse. If you remember, that was one little controversial issue, and there was a whole decision-making process on it. So looking at those email exchanges back and forth between all these departments and the drama as you go down these, half-redacted emails is fascinating to understand how the agency works and their issues with liability and things like that.
Did they actually give you reasons as to why certain petitions were denied? Because this is what happens a lot. There is sometimes this very simple technical reason for some things to get denied. And, if we could find out these things, would certainly help the industry.
So they don't really track why they deny petitions. You can even see that on the GAO report. They don't track that. But for us, we have seen patterns, or at least attorneys and agents have seen certain patterns. Like more recently, the denial of Vietnamese I-526 and I-829 petitions due to usage of a specific type of path of funds. And we see that as a major issue. And so we are basically going after that. And we do want to see the decision-making process as to why the agency is doing that. So our hope is with the FOIA that we're doing and the another litigation that we've done on that is we're hoping to get that information so that attorneys can defend their clients' denials or noids or whatever the response will be from the agency on those petitions.
It brings me to another question, Ishaan. We obviously have the trade association, AIIA, which is one of the most sizable collective groups of industry practitioners. And there's a lot of us immigration lawyers and security lawyers and stuff who are alongside the regional center operatives. Often we are at loggerheads with them, but we're still part of one industry. Now, with AIIA, do you encourage people like attorneys and others to join your industry, or are you satisfied with the size that you are in? Because I know you're quite sizable already.
No, not at all. In fact, I would say that we get a significant number of donations and engagement from members of the EB-5 industry. Everything from business plan writers to immigration attorneys to one or two regional centers who have donated to us and actively support us and tell their investors about us. And we greatly appreciate that. We actually have a membership program for industry members as well. And we have quite a few folks on that. And we actually share our FOIA releases and information with them as soon as we can. We think information is definitely important, but the other value I think that we really bring to the table with them is when we do resume our lobbying efforts, as we did during the lapse, we gave the industry folks who donated to us back then access to our lobbyists so they could have conversations with them one-on-one to actually get a real idea of what was going on the Hill, as well as letting their inputs also go forward to our lobbyists. So, and then we all sort of came together and have, in fact, a lot of the solutions we go after has been while working side by side with some of the most fantastic immigration attorneys in the industry. A lot of them, in fact, we mention them on our website.
Well, thank you, Ishaan. I know you've mentioned me as well, so I really appreciate that. But I actually didn't realize...
we have a vetted immigration attorneys list that is actually we compile alongside a lot of our members. And, a lot of our members, yes, you're right, are EB-5 investors. And so that is the main constituent, that is who we serve. And these are the main whose interests we like to protect. So if someone is looking towards the EB-5 program, whether you're a past investor or future investor, we hope to be the organization that they can turn to and find, a list of professionals and valid folks to actually work with and the right information too. So they can make a decision on, hey, should I even do EB-5 to begin with? Or what should I do now that I've made my investment?
It's very admirable, and we do encourage this, and we look forward to actually getting more from you on this. But I have to say, just like we are often at loggerheads within AIUSA, I can see that there would be areas that perhaps practitioners would argue against you. So, for example, you often give advice to investors looking to sue. And you have a whole couple of pages on your site, really with some good information. But don't you feel that EB-5 has become just ridiculously over litigious? And there are often times that investors just want a lawsuit, and there are practitioners out there just waiting to sue when really a lawsuit is not necessary.
We don't give legal advice. I want to be very clear on that. what we do is we want to give the information and the tools for a foreign national to know what their options are, whether it's to sue the government for a delayed petition, or it's to sue their investment issuer if they feel they've been defrauded, or their funds have been misappropriated, or whatever the case may be. They should have the information, the tools, and the knowledge to know what they have the option to do. And this is important, especially for foreign nationals who come from a very different system of governance and have dealt with courts in a very different manner in their home country. They should be allowed, and they should have the right to know, hey, this is what you should do if things go wrong. And look, this isn't a one-size-fits-all solution. We think that the information we give, which has actually been put together by a number of different securities and litigation lawyers, is really information that I feel is very basic and folks should know it. Just say, for example, knowing the difference between immigration law versus securities law. Because, for investors who have gone through issues with their project, they are afraid that if they sue their regional center, they may lose their immigration benefits, when that's not necessarily true.
Yeah.
As long as their money was spent correctly according to the business plan, they should get their conditional green card, and they should get their permanent green card too, as long as things were done correctly. USCIS doesn't care if the investor's project was successful or not. So at the end of the day, I just feel that, when it comes to like EB-5 being overly litigious or something like that, no, I in fact would say the opposite. I don't think it's litigious enough. I think a lot of investors aren't aware of what their rights are. And I think that's a big part of what we do, is make them aware, hey, this is what the US court and justice system provides to you. These are what each kind of lawyers do, and this is what they're capable of.
I do agree with you that it is good to know your rights and everything. But I also happen to think that there are times that litigation is not correct. And there are times that, unfortunately, an investor might end up spending funds he would not normally have spent on maybe litigation, which shouldn't really have happened. And I think there needs to be some caution put there. I mean, that is my opinion. I'm not into litigation as much, but I do feel like everything does not need to be litigated. And that's what it feels like.
I'd love to hear maybe more examples on that, but I'd also want to highlight that there have been investors who've been continually defrauded, continually faced with no options to take the case into their own hands. And, we're providing options to people when they have told that they have none. And I think that's what makes us different. And also, keep in mind that a lot of investors are in different situations and different offerings where different things have happened. So if an investor has faced issues in their project, or has faced issues with their investment issuer not being completely transparent with them as to how their funds are being spent, or where it's being, say, redeployed or something like that, that is a problem. And I think investors should at least deserve to know that, hey, these are my options, this is what I can do. And here's to respond to an earlier point of yours, which is they could be spending money on lawsuits and things like that. We actually now have relationships with litigation funders who are happy to pay for a lawsuit for an EB-5 investor in exchange for a portion of their final settlement. And if they lose the lawsuit, no cost to the investor. Now, I'm pretty sure litigation fund...
Don't think regional centers will like the sound of that, Ishaan.
No, of course not. I mean, who wouldn't? But that's my response to that would be, hey, just treat your investors right, do the ethical thing, and you won't get sued. There are regional centers out there that have zero lawsuits against them, that have never done anything wrong, and I think they uphold the right practices. Whereas there are regional centers which have been sued, which have been caught for doing not right things, and that's the way the world works.
I will argue against that one, because I think any regional center or anyone out there who's been doing this long enough, at some point they have been involved in a lawsuit, whether they've instigated it or whether it's been brought against them. But there are very few who have not. And if you have not, you really haven't been doing that much in EB-5. That's what I will say after so many years of experience within this industry and with working with most of the top regional centers in this country. So I will say that where I disagree also on overteaching is, I think that yes, you need to teach your members about things like redeployment. That's very, very important, and how one would go forward, and should there be the right to even discuss where your money is being redeployed. But unfortunately, many of your members will probably come to you after they've already signed up, and they may have already have PPMs and documents which prevent them from even having any say in redeployment.
Yes. I mean, I don't think there's anything more to say on that other than, yeah, that's true.
Yeah,
So,
yeah.
but at the same time, like, there are still options out there. I mean,
That's true. That's true. There's always options.
Yeah, your NC manager is supposed to be acting in your best interest. So if you feel that that's not the case, or if the money was, say, redeployed into some risky option somewhere, completely outside of the realm, that then you should do something about it.
How do you feel about those regional centers where the NCE manager is also the same as the JCE, whereas there really is no separation? I'm talking about regional centers where they own their own project. There's no third-party regional center.
I mean, I think it can go either way. There are some people who feel that having a separate entity that acts in your interest is important. Some people would say that it's nice to be vertically integrated. That way, the exchange of information and the transparency level could be marginally greater. But, at the end of the day, I don't think it matters. I think it boils down to the specific investment offering that the investor is looking into. And if it's a good offering, regardless of whether there's a separate NC manager or not, it's worth considering.
I don't agree there. Yeah. I think majority of times where you're looking at problem cases, you have the same manager who's the manager of the NCE and the JCE, meaning there is no separation. I'm not saying every instance, but I'm saying the greater majority of instance.
Well, this is what I would say. Well, now you're going to make other people in the industry kind of annoyed by saying that, because there's plenty of really good developers out there who run decent regional centers and have done right by their investors. So I don't feel like it's right to trash them either, because they have been doing a good job over the years.
Oh, Ishaan, with respect, I don't trash anybody. We work with all kinds of people, and we've had all kinds of people on our show, and we just like to bring different viewpoints. And we also like to let our listener be aware that this is the difference. There are differences between regional centers. A regional center where the owner owns the regional center, there will be lesser separation from a third-party regional center. This is just a fact. So but I don't believe that we do trash anyone in that. But let me ask you, AIIA constantly are filing lawsuits, and you currently have an amicus brief out there. What is your current amicus brief about? And perhaps you could explain to our listener what an amicus brief is.
Sure. We essentially file an amicus brief, which is a friend of the court. It sort of boils down to that. In a case that's being heard in the DC Circuit Court of Appeals. And I actually went for the oral arguments a couple of weeks ago, and it was fascinating. We filed an amicus brief before because we felt that case would be very precedent setting. If the decision is unfavorable, the DC Circuit Court could uphold the lower court decision, which was to dismiss the case and prevent any discovery from USCIS. This situation could negatively impact future I-526 mandamus cases and weaken the evidence that's actually held by those investors. And so and the impact of that could have ripple effects. I mean, it could make mandamus cases that are filed in DC practically impossible. So we felt this was really important to do. So when I went for the oral arguments, I was with Judge Cornelia, Judge Florence, and Judge Karen Henderson. And, going there in person was such a riveting experience for me to actually see their body language as Jesse Bless and Brad Beneas, two fantastic lawyers who made their oral arguments on this case, and watching how the judges responded to them was, I don't know, for me, it was a really big and important experience. It kind of taught me, first of all, how judges view the issues when it comes to delays of investor cases. And people say that the one specific judge, Karen Henderson, was more conservative, the other two are more liberal. And initially, I didn't think much of it, but then as I began to sort of notice the questions that they were asking the attorney that was representing the government, I began to realize how the difference between what a liberal versus a conservative judge is, especially in the case of a delayed immigrant petition. Anyway, so that's kind of in short for us. It was important to be involved in this case. We really do hope that the circuit court will reverse the lower court decision and will allow this case to move forward, allow for discovery to continue. And I think it would also it would also give future mandamus a much stronger precedent to claim USCIS has harmed investors in EB-5 through their really long processing times.
Well, I think it's a very admirable case because from all that we're hearing, and there was an AIUSA program just a week ago, and from just talking with other practitioners, mandamuses for I-526s are not doing well right now. I think courts are a bit fed up, so something like this would definitely be a good idea. And I know myself from the day when I used to do oral argument, it can be quite daunting, especially if you have a judge who is about to pounce on you at any point, and you can totally lose your train of thought. So it's good that you actually saw all those, what was happening. But with regards to the body language, what did you see in the body language? Do you feel like there's some sympathy towards the investor who's been invested their life savings and been waiting forever?
Yes, I'd say up to a certain extent, but a lot of that also just stems from the inefficiencies of USCIS. To respond to one of your earlier points about judges and how their responses, I think it's really important to understand that judges are human beings, right? And if they go to their court and they look at their docket for the day and suddenly they're seeing a whole bunch of mandamus cases in front of them, they're like, what the heck? Like, I'm a federal court judge. I'm here to decide big decisions. Like, in fact, right before the case that I attended, the oral arguments for this particular case, right before that was a January 6th person who had stormed the Capitol with a stick. And we were hearing his attorney sort of make his case, and those same judges. And, when you're a judge in that sort of space and you're listening to these arguments, like you want to do, of course, what's right, but you can also get fed up if a whole bunch of people are just suing the agency. Yeah. So yes, I can see I-526 mandamuses perhaps losing a bit of their magic if, two judges are getting too tired of it. But from what I learned, like watching their body language and listening to them respond to the government attorney, is what I realized is that a good argument, a good debate that you put forward really can make a world of a difference. Where I think the liberal judges specifically were able to push back on was when the government attorney said, well, USCIS is doing the best they can, and they're following their procedure of adjudicating cases. And so the judge says, okay, government attorney, what is their procedure? Because apparently it's not first in, first out. So why don't you tell us? And the attorney was like, I don't know. And just watching their flippant reaction, which was like, hey, this entire case that we've come to argue is on the fact that, some cases are getting approved ahead of others. And there's, a backlog that's been created. It's impacting immigrants who are coming into our country. Like, come on. So, I think that's where I feel, yes, I-526 mandamuses could be lost, blah, blah, blah. But at the same time, if you have a really good attorney who knows what they're doing and can present solid, coherent arguments based on good evidence, I think can make a world of a difference.
Well, where I'd like to really see some assistance here, Ishaan, and I've been trying to advocate for this, is the fact that since AIIA, since that was passed last year, any cases which were denied are denied, have to go through the AAO before we can go to federal court. And we are seeing cases denied for absolutely stupid reasons, for just maybe an officer who doesn't understand the industry, or an officer who's just got their facts wrong, or things which are blatantly there and they've ignored. And I'm talking just generally, because from talking generally with different attorneys, now going through the AAO decisions are supposed to take a few months, but traditionally for EB-5, exactly. And this is where we fear problems are going to be. So we certainly would encourage any kind of action to help AAO petitions, which are just being stuck there before we can go to federal court.
To be fair, we did lobby against this back in the day, and
you did.
We actively did. We made this a priority for ourselves, and I'm also vehemently against this. It's really just going to have to be come back to us and IUSA, the other bodies, to all come together, and we should lobby to perhaps have a change. From what I do understand, that USCIS definitely made a request to the legislative staffers to put this in.
Yeah, they did. And Senator Grassley was very firm on this one, because we also tried to lobby against all of this. A lot of the immigration attorneys did, and most of the immigration attorneys did. So, but yeah, we have to live with it thus far, but let's see. Litigation may rule the roost here. Ishaan, you and I can keep on going for hours on so many different topics. And it is a real pleasure to speak with someone who has the inside knowledge, and I appreciate that. But getting back to this calculator of yours, when can we expect it to be up and running?
That's a good question. And honestly, it's so complex that it's definitely been hard for us to find a time when we can definitely release it, because we keep finding, one or two issues with it that we want to fix. And look, I really do want people to get the best use out of it, because keep in mind, this calculator allows you to choose your variables based on, what you think is most likely to happen. Right. So what we've done, what our calculator does is it combines the I-526 information with reports on things like the visa stage demand from DOS and CIS, and further applies assumptions based on approval rates, survival rates, and family size. And then based on, all that data, you can sort of come out with the number of pending applicants in front of you. And then we can split that up over a period of time to then say, okay, your visa would be available at X date. So I'm just going to vocally describe an example. So let's just say you're an Indian applicant as of March of 2022. So now we know at the I-526 pending stage, at March of 2022, you have 2,175 petitions pending, right? Now let's multiply that with, say, 2.26 visas per principal. That's about 3,600. Now we have about 1,900 people waiting at the consulates for a visa interview. We have about 700 people waiting at the 485 stage. Now you add that up, you're basically looking at about 6,200 sort of pending applicants in front of the March 2022 investor. Now you sort of look at what will the supply be between, say, 2022 and the next 10 or so years. Let's just say about 700 visas. And then you divide 6,200 with 700. And now you can make an estimate of, all right, 9 years. That'll be like 2030. So in this assumption, I did sort of multiply in a 90% I-526 approval rate. And I did add in about an 83% visa stage approval rate, meaning people who will actually get their visas from NVC and through their 485. But now if I were to change up these figures and let's just say assume a 100% approval rate for India, and then a 100% I-526 approval rate and 100% approval rate through the 485 and the NVC stage, and maybe make the family size something like 2.6 or 2.7, now it's now the waiting time just went up to like 2030 something. And so the calculations can change depending upon the inputs that you have. And of course, look, we know for a fact that this is not necessarily going to be the most accurate assumptions. We also feel like our calculations are likely to be more optimistic than the realistic wait times, just because, the first in, first out processing is hard to say. We don't know how many unused visa numbers will actually drop into the employment-based categories. Right. So because of those unknown variables, we don't know exactly how this could be. We also don't know if people will drop out, if a lot of people through their wait times will start getting married, having kids, etc. There's so many unknown variables there that it may not actually be accurate. It may take you much longer than whatever our calculator says.
And also, Ishaan, quite a lot of people in the process, especially in the 2019 process, if they were EB-2 applicants, managed to get their numbers pushed up earlier than expected. So they would have dropped out. We've had a lot of withdrawals from every project.
Yeah, exactly. So because of that unknown factor, it's hard to say. But I think this, at least look, as the data gets clearer and better, and as we try and account for all the pending petitions and we get the latest updates on who's being withdrawn, who's not, then, we can probably give a clearer and clearer estimate as time goes on. But regardless of all of that, the reason why we're putting together this calculator is because it's really just important for investors to know what an estimate looks like. So they don't have folks that are lying to them and saying, oh yeah, you'll just get your green card in just a few more years, like a lot of agents, for example, don't exactly have much idea of when their past investor will actually get their green card. And hopefully, they'll use tools like this and be able to educate their past client on what a more accurate estimate could be.
Well, so Mark, I think we should have Ishaan back to tell us how this has worked, maybe in a few months' time.
Sounds great. Ishaan, thank you so much for coming on EB-5 Investment Voice.
Absolutely. Happy to be on.
Thank you for being with us today on EB-5 Investment Voice. The topics presented in this podcast is informational in nature and is not to be taken as specific legal advice. If you have questions on the topics presented in this episode or other investment immigration needs, please contact Mona and Associates. Mona and her attorney staff can be reached at mshawlaw.com. That's mshawlaw.com. shahlaw.com. Make sure you don't miss our next episode focusing on a different aspect of the EB-5 program by subscribing to the podcast. While you're at it, leave us a rating on iTunes. If you really found this episode valuable, share it with someone else that could benefit from this information. Until then, I'll see you on the next episode of EB-5 Investment Voice.